Welcome to Discourse Politics, the place for political and social commentary. My nose is stuffed again, but I don't care, I'm gonna record. Today, Texas dropped a bombshell on everybody and sued the swing states. This is not legal advice, this is for entertainment purposes only and all that other legal jazz, but let's dig into what was actually filed with the Supreme Court. In the Supreme Court of the United States, the state of Texas is the plaintiff versus the Commonwealth of Pennsylvania, the state of Georgia, the state of Michigan, and the state of Wisconsin. Fun fact, there are 4 commonwealths and 46 states that make up the 50 bulk states of the United States that most people think of. So in reality, if you ever asked on a game show how many states are in the United States, you have to clarify, are you including the commonwealths of Pennsylvania, the Commonwealth of, I believe it's Pennsylvania, Ohio, Massachusetts, and Delaware? I'm not sure. There's 4 commonwealths that are technically commonwealths as per their state constitution. So here is the bill of complaint. Non-legislative actors purported amendments to states' duly enacted election laws in violation of the Electors Clause, vesting state legislatures with plenary authority regarding the appointment of presidential electors. The second thing is interstate differences in the treatment of voters with more favorable allotted to voters, whether lawful or unlawful, in areas administered by local government under Democrat control and with populations with higher ratios of Democrat voters than other areas of defendant states. Third, the appearance of voting irregularities in the defendant states, which later on in the filing, we'll get into the actual statistics that they use. According to them, it is essentially astronomical, the odds of Joe Biden actually winning all these swing states, and it'll go briefly into that later on inside the complaint. The appearance of voter irregularities in the defendant states that would be consistent with the unconstitutional relaxation of ballot integrity protections in those state election laws, basically saying that with the changes in the laws that were made, the way that ballots were counted, and the sort of lax laws pertaining to mail-in ballots, that is what caused the unconstitutional appearance of these voting irregularities. So it says all these flaws, even the violations of state election law, violate one or more of the federal requirements for elections, i.e. equal protection, due process, and the Electors Clause. So those 3 things are pretty common throughout this complaint, and thus arise under federal law. See Bush versus Gore, 531 U.S. 98th 113, 2000. Taken together, these flaws affect an outcome determinative number of popular votes in a group of states that cast outcome determinative numbers of electoral votes. In other words, if this was not outcome determinative, then the Supreme Court would likely not even bother taking up the case. I still wonder if they're going to take up this case because there is an issue of standing, which later on in the complaint, it will actually get into their legal standing. But nonetheless, I think that this is going to be an interesting case if the Supreme Court chooses to take it up. The reason they're making this application into the Supreme Court, this court, meaning the Supreme Court, is the only forum that can delay the deadline for the appointment of presidential electors under 3 U.S.C. 5-7. So then we get into the nature of the action. Plaintiff states or alleges that each of the defendant states flagrantly violated constitutional rules governing the appointment of presidential electors. See Marbury versus Madison, which is actually something I remember studying in constitutional law. So as Justice Gorsuch observed recently, government is not free to disregard the Constitution in times of crisis. Yet recently, during the COVID pandemic, certain states seem to have ignored these long-settled principles. It goes on to say, state officials sometimes through pending litigation, settling friendly suits, and sometimes unilaterally by executive fiat, announced new rules for the executive conduct of the 2020 election that were inconsistent with existing state statutes defining what constitutes a lawful vote. State officials, the executive branch, and even the judicial branch, which I don't think it listed here, but it is basically saying everybody except the state legislature putting their hands in the cookie jar trying to sort out elections and election law. That could be construed as unconstitutional because the authority under Article 2, well, we'll get into it, but the authority under Article 2, Section 1, Clause 2, I believe, is that only the state legislatures have the sole authority of electing state electors to the Electoral College. So then it goes on here to say that defendant states also failed to segregate ballots in a manner that would permit accurate analysis to determine which ballots were cast in conformity with the legislatively set rules and which were not. In other words, because sole authority is vested in the state legislature is the final say on what rules and time, place, and manner, and the way in which electors are selected. If the rules that were approved by the state legislatures were deviated in any way except from the state legislature, the claim here is that it is therefore against the Constitution. So whether it's an executive branch making a change, whether it's whatever. So when any official failed to segregate ballots in a manner that would permit an accurate analysis to determine which ballots were cast, it basically is saying that when they changed the rules on how to count, the moment they deviated from what was allowed by the state legislature was the moment it became unconstitutional. It goes on to say that, this is especially true for mail-in ballots. In every swing state, the mail-in ballots were treated in a way that was counter to the way that the state legislature had authorized it to be treated. And that's the key point, is that because the Constitution vests all power in the state legislature is the only body that can change the rules of how these elections to choose the electors are determined, and the processes by which a ballot would be valid or invalid. The rampant lawlessness arising out of defendant states' unconstitutional acts include the following: dozens of witnesses testifying under oath about the physical blocking and kicking out of Republican poll challenges, which again circles back to the state legislatures allowed these rules to allow that these poll watchers had the legal right to be there. And so by them being kicked out, by them being blocked, by them even sometimes being slowed down from getting in the room as per, having to get court orders that were then not even enforced because they're deviating from the law on such a wide scale, going against the state legislatures, that would be unconstitutional. Videos of poll workers erupting in cheers as poll challengers are moved from vote counting centers, poll watchers being blocked from entering vote counting centers despite even having a court order to enter, suitcases full of ballots. They shouldn't have used suitcases full of ballots. They should have said boxes full of ballots, which would have just been an all-encompassing, but whatever. Suitcases full of ballots being pulled out from underneath tables after poll watchers were told to leave, and then facts for which no independently verified reasonable explanation yet exists. On October 1st, 2020, in Pennsylvania, a laptop and several USB drives used to program Pennsylvania's Dominion voting machines were mysteriously stolen from a warehouse in Pennsylvania. The laptop and the USB drives were the only items taken, and potentially would be used to alter vote tallies. In Michigan, which also employed the same Dominion voting systems on November 4th, 2020, Michigan election officials have admitted that a purported glitch caused 6,000 votes for President Trump to be wrongly switched to Democratic candidate Biden. A flash drive containing tens of thousands of votes was left unattended in Milwaukee tabulation centers in the early morning hours of November 4th, 2020, without anyone aware it was not in a proper chain of custody. It then goes on to say, expert analysis using a commonly accepted statistical test further raises serious questions as to the integrity of this election. Now, I said earlier about the probability, and we'll talk about it later. Well, here's the probability that they came up with. I'm not sure what math they're using behind this, but this is what's in their complaint. It says the probability of former Vice President Biden winning the popular vote in the 4 defendant states, Georgia, Michigan, Pennsylvania, and Wisconsin, independently given President Trump's early lead in those states as of 3 a.m. on November 4th, 2020, is less than 1 in a quadrillion chance. The chance of winning all 4 of those states is 1 in 1 quadrillion to the 4th power. Comparing it to Hillary Clinton's performance and coming to some analyses, it's 1 in 1 quadrillion to the 5th power. So it's getting even worse. And then it goes on to say, put simply, there is a substantial reason to doubt the voting results in the defendant states. By purporting to waive or otherwise modify the existing state law in a manner that was wholly ultra vires, which ultra vires is beyond one's legal authority or power. And basically what that's saying is the way that they modified their mail-in ballots was beyond the scope of what they legally had the authority to do, based upon the Constitution, Articles 1 and Article
Article 2 is the process of selecting electors. The state of Texas is saying that their voters are entitled to a presidential election in which the votes from each of the states are counted only if the ballots are cast and counted in a manner that complies with pre-existing laws of each state. The number of absentee and mail-in ballots that have been handled unconstitutionally in defendant states greatly exceeds the difference between the votes totals of the two candidates for president of the United States in each defendant state. In other words, if this were just a few ballots here or there that wouldn't make a difference, then it wouldn't make a difference to the outcome. But they want to make it clear that the number of ballots that were handled unconstitutionally actually exceeds the difference of the vote totals in each of the states that they're filing against. So what they're seeking is declaratory relief for all presidential elections in the future. This is kind of important. So what they're basically saying is, not only is this election at stake, they want the Supreme Court to weigh in on future elections as well. They want them to set a precedence, basically. And at the end of the day, the question becomes, will the Supreme Court actually, come in and do it? Then it gets into parties and backgrounds. And we can skip all of that because it's basically just who's who among who. I'm going to do a separate video for each state, or maybe a separate video for all the states for what's being alleged, because this is the legal arguments for each state. And it's kind of important. But right now I want to just focus broadly on what this lawsuit is about, and then I'll get into probably each state, and I'll maybe make a part 2, part 3, part 4, part 5, or maybe I'll just lump them all together. Depends on how long the video is. This video is already getting too long, so I'm just want to go to one more thing. What they're basically saying is the swing states violated the Constitution on 3 counts. Every argument that goes before the Supreme Court is basically arguing that in some way and in some manner, someone violated the Constitution. And so here is where they state those the three ways in which swing states that they're suing have violated the Constitution. So count 1 is the Electors Clause. What they're saying is that the Electors Clause of Article 2, Section 1, Clause 2 of the Constitution make clear that only the legislatures of the states are permitted to determine the rules for appointing presidential electors. So I've been saying all along, a lot of people have been saying Article 1, Section 2, or whatever, blah, 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 blah. I've always said that the power actually comes from Article 2, Section 1, Clause 2 specifically. Only the state legislatures have the sole authority for permitting to determine the rules for appointing a presidential elector. Therefore, any non-legislative actors who changed or amended or nullified election statutes, they lacked the legal authority to do so and therefore violated the Constitution. Under Heckler versus Cheney, conscious and express executive policies, even if unwritten, to nullify statutes or to abdicate statutory responsibilities are reviewable to the same extent as if the policies had been written or adopted. Thus, conscious and express actions by state or local officials to nullify or ignore requirements of election statutes violate the Electors Clause to the same extent as a formal modification by judicial officers or state executive officers. Put another way, let's say local officials in a certain county decided that they were going to ignore the rules about what is and is not a valid ballot. Like, let's say they're not going to scrutinize signatures, or they're going to accept ballots that don't have a date of birth, or they're going to accept ballots that were turned in, mail-in votes, but they don't have, like in the state of Wisconsin, a corresponding application for those votes. What they're basically saying is that if local election officials or even someone counting a ballot starts making modifications to the actual law, those conscious actions that may or may not have been sanctioned at whatever level would rise to the occasion of being considered a violation of the state legislature's ability to have control over how state electors are chosen. Therefore, if there was a large enough group of votes that did not go under the scrutiny that they were supposed to have gone through, then those votes would technically be invalid because the state legislature had approved those votes to be scrutinized in a certain way. Basically saying all changes and any changes that were not made by the legislature. Again, it keeps circling back to the idea that only the legislature has the authority. So electors appointed to the Electoral College in violation of the Electors Clause cannot cast constitutionally valid votes for the office of the president. In other words, because they violated all these laws, any electors that they send that were elected in an election that violated state law would therefore not be able to cast a valid vote in the Electoral College. Count 2. Does the way that the states handled their election violate the Equal Protection Clause in the Constitution? The Equal Protection Clause prohibits the use of differential standards in the treatment and tabulation of ballots within a state. With this case, what's specifically at hand here is, and I know at least in Pennsylvania this happened, but it may have happened in other places, where people were allowed to cure ballots. Those places are heavily Democratic, so they basically give an unequal treatment of votes. Therefore, that would violate the Equal Protection Clause under the Constitution. Number 136, the one person, one vote principle requires counting valid votes and not counting invalid votes. Basically, the one person, one vote clause could be used to say, look, every time you count a vote that was not cast or scrutinized legally that should not have been cast, you dilute my power, the power of my vote. All votes that were legally cast need to count on a one-for-one basis. And therefore, if a vote was cast that was illegally cast and did not follow the proper procedures, then it's diluting legal votes. So the one person, one vote principle is basically saying that under the Equal Protection Clause, my vote is supposed to count as one, but every time you allowed a vote to come in that didn't have proper signature, every time you allowed a vote to come in that didn't have an address, every time you let one come in that didn't have an application for an absentee ballot, that was diluting my vote because those are illegal votes being illegally cast. Even if it was a valid voter trying to make that vote, it was still an illegally vote cast because it did not follow the rules and procedures set forth by the legislature, which was the sole authority for how to appoint electors to the Electoral College. By the shared enterprise of the entire nation electing the president and vice president, equal protection violations in one state can and do adversely affect and diminish the weight of votes cast in states that lawfully abide by the election structure set forth in the Constitution. So this is trying to formulate legal standing. In other words, because Texas held its election in accordance with the Constitution, they are harmed by the fact that other states did not follow the form of the Constitution. Therefore, their legal standing to sue is because we are in an entire nation electing a president and a vice president, and the states that refused to follow the Constitution and actually count the votes the way that they were supposed to be counted as set forth by their state legislature, because they violated the Constitution, it harms the people of Texas. The swing states did not handle their elections lawfully, legally, and constitutionally. So that was the standing that they're trying to make. Texas is harmed by the fact that these swing states suck at the way that they handled their elections. And then finally, count 3, due process. When an election practices reach the point of patent and fundamental unfairness, the integrity of the election itself violates substantive due process. So then it goes on to say, under the court's precedents on procedural due process, not only intentional failure to follow election law as enacted by states' legislature, but also random and unauthorized act by state election officials and their designees in local governments can violate the due process clause. And finally, the defendant states acted unconstitutionally to lower their election standards, including to allow invalid ballots to be counted and valid ballots to not be counted, with the express intent to favor their candidate for president and to alter the outcome of the 2020 election. In many instances, these actions occurred in areas having a history of election fraud. In a nutshell, that is sort of the case, that they basically are saying that the swing states, Pennsylvania, Georgia, Michigan, and Wisconsin, all violated the Constitution by how they conducted their elections, by subverting the power of the legislature in the way that they conducted the count of the votes. So it's an interesting legal argument. I don't know where it's going to go. I don't know how successful it's going to be, but I'm just going to say that it is pretty interesting, to say the least. So anyway, I'll be putting out videos shortly that go into each state, the complaints in each state. But nonetheless, thank you for watching. Like and subscribe, and make sure you share this video with friends and family. I will see you next video.